practice in Jerusalem for the last, I think, 53 years, 52 years perhaps. And in general practice in real estate, wills, court cases, divorces, and successions, probates, and various other things. I would like to talk to you about a legal tool which is called an enduring power of attorney. What it is and how it's used and why it's important to each and every one of us, me of course included. Let us start by saying what situations this document is designed to cover. A power of attorney, as you obviously know, is a document which enables somebody to act on your behalf. Now, normally speaking, all powers of attorney are valid so long as the person who gives them is alive. If he dies, then the power of attorney dies with him. Also, something which most people do not know, if he becomes unable mentally to cancel the power of attorney or change it, then the power of attorney, legally speaking, is also invalid. Now, the human being goes through 3 different stages in life. First of all, they're born until the age of about 18, sometimes 21, depending upon the countries. They are not legally capable of conducting legal business, signing contracts, etc. When they are adults from the age of 18 upwards, they are legally capable and can conduct any business or execute any document which they wish. When they die, of course, they can do nothing, and then the will takes over. But there is a period of time which can happen, and unfortunately we see around us, it happens many, many times, when the person is alive but not capable of looking after his own affairs, mentally. I'm not talking about physically, I'm talking about mentally. That's to say, he doesn't understand well enough, he doesn't coordinate well enough, he doesn't communicate well enough. In other words, he is not mentally capable of dealing with his affairs. This is the period when an enduring power of attorney is very, very important, because it can last for the length of the time that that person is incapable until he dies, and empowers other people whom he chooses to conduct his affairs for him. Now, up until recently, in fact, up until 2018, this facility does not exist. If your parent, father, mother became, should we say, sick with Alzheimer, or in any other way mentally incapable of looking after himself or herself, then you would have to get a social welfare officer's report, a medical opinion, make an application to the court, the family court, and get somebody appointed as an apotropos, which is a guardian or custodian for that person to deal with his affairs. But that didn't stop there, because at that point, whatever he does, or whatever he would have done up until the law changed, would have had to have had the approval of the court. If he wanted to sell a house and move into a home, he would have to go back to court. If he wanted, in fact, everything he needed to do, he would have to get court approval, which is a very cumbersome thing to do, and of course it's expensive. In addition, he would have to report, give a financial report to the apotropos klali, which is the custodian general of the country. He'd have to give an annual report of what he's done with the money of that person that he's managing. It was very, very complex, very cumbersome and very expensive, and it was not a good system. And it lacked, of course, one very, very important element, and that is the element of the personal input of the person himself. Who would he like to be his power of attorney? What would he like that person to do, and how to be dealt with? That was not possible because when the course of the family court made the order, the man or the woman was already incapable of expressing any will or desire of his own. So they enacted the law called enduring power of attorney, which means as follows. Any person can now, today, while he is fit and well and mentally 100% capable, he can dictate in advance what is to happen to his affairs. He can say who should look after them, what things that person should look after, how the person should look after those affairs, when he should start looking after them, when he should finish looking after them, etc., until that person, the donor, the appointor, dies. Of course, when the person making the power of attorney dies, the power of attorney ceases to exist, and his will comes into effect to deal with his assets and his personal affairs. Okay, so we have the ability to make these decisions in advance for ourselves in the event that we become incapable of acting for ourselves. It's a sort of insurance policy. You know, most insurance policies are you never call upon them. You pay your premiums for the whole of your life. At the end of the day, you paid a fortune and receive sometimes nothing at all, sometimes very little, but occasionally it pays off, and it's a good thing that you were insured because that is the money that you needed at the time. This is one of those events. That it's an insurance policy so that if you have that document and you do become incapable of managing your affairs, then this document comes in and covers and tells everybody what you wanted to happen in your good and waking and alert years. Okay, having said that, what actually happens? Well, the first thing is that the person has to decide who it is who will determine that he is not capable. Now, if it was myself, for example, I'm not allowed to have a person determine if I'm capable or not, if that person is going to be my power of attorney. Obviously, because there would be a conflict of interest. And for example, if I want to appoint my son as my power of attorney, and I also appoint him to determine whether I'm well or not, well, so he's got everything in his hands. He can suddenly say, my father's passed it, I'm taking control, and that's it. It may be true and maybe not true. So they've covered this problem by saying that the person who decides as to whether or not you are capable must be an independent person, somebody who is not appointed as a custodian of your affairs if you're in that situation. The most obvious thing is but of course you can appoint two people. For example, the most obvious is if I were to appoint perhaps my doctor, a doctor who knows me, who's been dealing with me for some years. I say to myself, if that doctor knows that he sees me and he sees what the condition that I'm in, if he thinks that I'm not fit, then I'm prepared to accept the fact that I am not fit. So most people appoint a doctor. A lot of people appoint a doctor together with one of the family, who can be one of the people who he is appointed as a power of attorney. But that person can't act alone. It has to be the two people together. So the normal thing is to decide, I will have my doctor together with my wife or my husband or my son or my daughter, or all of them or some of them, whatever you want. And those are the people who would decide if I happen to get, unfortunately, into that position that I need a power of attorney. The next thing, of course, the person needs to do is decide who is going to be the power of attorney. Now, this is sometimes very, very simple. Most times it's very simple. Sometimes it's not simple and it's not obvious. And the important thing is that you are the person who say who's going to look after your affairs. Let me give you an example. Let's say I have 4 children. 3 of them I'm in very good terms with. One I'm not really, I don't like the way he's going. He's gone, to my mind, he's on the wrong path in life. I don't like it. I wouldn't want him to look after my affairs. So I appoint the person I want to appoint. in the past, if I had, for example, 2 sons, 2 daughters, and I'm not able, if the enduring power of attorney wasn't in operation, and I have to go to court, the court can appoint who they like, who they think is fit. And that may not be the person that I want, that I don't want. Another thing is that if I have 2 children, for example, and they don't talk to each other, I'm in very good terms with both of them and my children, but they don't talk to each other. And this does happen. Unfortunately, it happens in a lot of lives, a lot of homes, and it's very uncomfortable. And you can't, therefore, properly think about appointing both because they're going to disagree, or even one, because the other one may disagree and they may cause all sorts of problems. So these things need to be taken into consideration. And of course, the choice is entirely personal. What is important to you, your family at that time? That's what you choose. So you decide to choose a person to look after your assets, your business, your property, your money. That may not be the same person that you want to look after your health circumstances. For example, I have a son who's in business, and I have a daughter who's a nurse. It would be very nice for me to appoint my son to deal with the assets of my property problems, and my daughter to deal with my medical problems, my personal problems. If a woman is making an enduring power of attorney, she can choose usually a daughter to deal with her personal problems, things which are not business and not health, but look after me, how I look, make sure I'm always tidy and pretty and made up and looking like a proper person with dignity. That you give to, for example, a daughter. In addition, you can choose custodians who are more than one. You can have 2 children or 2 people. It doesn't have to be children. We'll go into that in a minute. For example, I have four children, and I want to be fair and make them all feel that I rely on all of them. So I say, right, my eldest son will look after my business. My eldest daughter will look after my medical situation. My third daughter will look after my personal affairs. And in the event that any of them cannot do it, then my 4th child will step in their place. All sorts of combinations, 2 and 1 to step into place, or all 3 together, or 4 together, which is not very comfortable, but you can do it, or whichever way you want, as regards your own personal situation. That's the important thing. It's your own personal situation. Now, when you choose a custodian or a power of attorney for your affairs, you divide your affairs into 3 sections. Business matters, property and money things is the 1 section. Second section is medical, and third section is personal. Your power of attorney can be the same for all of them, different for all of them, and any mixture of 1 or 2 or 3 of them for whichever one you want, whatever is good for you. Now, there's another situation. Let me just, before we do that, we say you don't need to appoint children. Sometimes, in fact, it's not good to appoint children, and I'll tell you why. A couple came to see me to do an enduring powers of attorney. They were a very happy, loving couple. Both second marriages for both of them. They've both been widowed. He had 4 children. She had 3. She was, in fact, the one who was wealthier of the 2, but it didn't matter. They kept a joint household and everything was fine. Now, she said, I rely on my husband to look after my affairs. I really do. But I have children, which are not his children. What do I do about making sure that they're properly looked after while I'm not capable of myself of dealing with it? It's a very good question. And so what did we do? We said that as far as her financial affairs are concerned, she appointed her husband together with her lawyer. Now that solved that problem. All these little problems can be solved with a bit of ingenuity, but make sure that what you want is what is going to happen. Okay, now there's other situations which can arise, which are important, and they often happen. And that is, if you have, say, 4 children, one of whom is permanently abroad, he's not here at all, doesn't live here, comes occasionally to visit, on good terms with everybody, etc., etc. It is not practical to appoint him as a power of attorney. He's not here to deal with things. He can't sign everything that needs to be signed. He can't run to the bank. He can't do anything properly. Theoretically, he can. Practically, he can't. And so they created another function which is called a miyuda, which means somebody who has to be kept informed. Now, somebody who has to be kept informed has the right to know everything that you, as power of attorney, are doing. And if you do not give him that right, then he can enforce that right. It's his. It's your as a donor. It's your will that that child who lives abroad should be in touch with everything, and they have to abide by that. He is called a miyuda, and he has a special function and a special status. There's a very important status. Okay, having decided who's going to determine whether you're fit or not fit, having decided who's going to deal with your affairs, your medical, your personal, and your assets, if you're not capable, the next thing you have to do, and this is the biggest thing of all, is to decide what sort of instructions you're going to give him. Now, this is an open paragraph on the form that needs to be signed. And it's an open paragraph because you can put in there whatever you like. Now, I'm going to give you an overview of some of the things that people want to say to the people who are going to be looking after them, how they should behave and what they should do, how they should look after him, etc. Now, I'm going to go through the items that I have recommended and people themselves have recommended, what sort of things you can tell your power of attorney to do. Okay, the first thing that I often recommend, and people seem to like it, is that I express my sincere wish. I'm now talking as if I am the person making the power of attorney. I express my sincere wish that my children keep full harmony between them, as far as possible, be in unison and in agreement with all the decisions which they have to make when they decide what to do for me. Second thing I would like to say, perhaps, is that I would like to be cared for at home, or maybe not, and by a carer, or maybe not, and so far as it's practical. And sometimes, perhaps, to say that if it's not financially or physically practical to do so, then what to do with me? Send me to a home, with a carer, without a carer. All these things you can tell a person in advance. One thing that a lot of people like to say in this power of attorney is as follows. If I am in a life-threatening medical condition, I wish that I be allowed my personal dignity, and apart from treatment to relieve pain and distress, that my attorney should not artificially prolong my life. If there is any chance that I could regain quality of life. Another thing that I would say is that they should be careful about giving instructions to their power of attorney with regard to their assets. There are certain assets which need to be dealt with in a certain way. For example, if I'm a lawyer in practice, I may wish to say that if any problem arises with any of my files after I'm no longer capable of dealing with myself, they should be in touch with my partner or my ex-partner or a friend, and they will be able to help me. If there's a problem with any assets of mine and my affairs are being dealt with by an accountant, I can tell my powers of attorney to continue to consult with and take the advice from this same accountant. I can also say, if dealing with me uses up all my free assets, then I can give them permission to sell some of my fixed assets in order to continue to look after me and cover those expenses. I may wish to say that I've no objection for my attorneys to sell my house in order to move me into more modest accommodation. For example, if I'm not then living with my wife has died or whatever, and I'm alone, it would be stupid for them to continue looking after me in a huge house, which was good enough for a family of 5 or 6 people, but now is way too big and too expensive for one single person to be looked after there. So I can say, you have my permission in advance. You can sell the house, take some of the money and use it for more appropriate size accommodation for myself. I may wish to tell my powers of attorney that I've signed one of these ADI forms that if anything happens to me, they can use parts of my body for medical reasons or to save lives. I may wish to tell my people that I've got a burial plot, and they should not forget it when I die, that they should know that there is a burial plot. I may wish to say to my powers of attorney that over all the years I've been making charitable contributions. Perhaps I've been supporting one particular charity all my life. I would like to say, even though I'm not fit, while I'm alive, please continue to support that charity. Then I may want them to do some other things which are even more personal. I've had people say, every year we meet together as a family, or we go away on holiday together once a year as a family. Please continue that custom. It's a wonderful custom. Continue it while I'm still alive, even though I'm not capable of doing anything about it. Another thing that somebody once said to me, and we put this into their power of attorney, is this. If I'm, this is a very interesting point that they brought up. The lady says to me, if I am not with it, it's highly likely that I'm going to be physically not in a very good condition as well. I don't want my grandchildren to see me like that. I want them to remember me as a full, proper, active, and 100% aware human being. I don't want them to see me at my worst time. So therefore, maybe restrict my visits to me, only to my children and their spouses, nobody else. That's for my own dignity. Okay, these are just some of the things that you may wish to put into your general instructions to your power of attorney. Now let's just talk about the procedure. What happens is this. You go to a lawyer, and it has to be a lawyer with special preparation, who has officially finished the course, a particular course by the Bar Council, and is qualified to deal with enduring powers of attorney. There is a list if it's needed. I'm one of the people on the list, but there's a lot of lawyers now that are doing it, but it has to be that particular person with that particular qualification. Then you have a meeting with him or her, and you go over all these points that I've raised one by one, make your decisions on what you want to do. Then that could take well over an hour and a half, maybe even more. Incidentally, when you do so, only you should be present. Now, if you're doing a power of attorney together with a spouse, a husband or a wife, it's okay for them to be present too, but not anybody who is going to be appointed as a power of attorney. That person must not be present, not when you give the instructions. Okay, so then the lawyer will take away the details that is noted and draw up the form, which can be anything between 13 and 23 pages. Sounds a lot, but it's a form, and he will prepare the document. He will then make another appointment with you and go through it item by item to make sure that each of the things are exactly as you want. Having done that, the next thing is for you to sign. Your signature has to be in front of the lawyer who makes this power of attorney. Every single person that you appoint as a power of attorney, not as a miyuda, not as a person who needs to know, because they're usually not around, every person that you appoint as a power of attorney has to sign his agreement. The signature has to be done personally, preferably in front of the same lawyer. It can be in front of a different lawyer, but it has to be on the same piece of paper, on the same 13 or 20-page document that was been prepared. So which makes it rather cumbersome. It's better if it's all in front of the same lawyer. At that point, if everything's okay and the lawyer checks it through, it's then submitted and it goes by online through the computer straight to the Ministry of Justice. And there it's checked and rechecked. And if it's okay, it's approved. And everybody concerned, that's to say, the lawyer and the person making the power of attorney, and usually the people appointed as well, will get a copy in their mail of the same document with a court stamp on, or the ministry stamp on it. And that's the official stamp. And then hopefully you put that away in your cupboard, put it in your safe, forget about it until such time as, unfortunately, it may have to be activated, at which point the people that you decided should determine your mental state will then do so. That goes to the ministry. The ministry will then validate the document, and from that moment on, the people who have been appointed with that document in their hand can say, I'm authorized to deal with all these matters on behalf of my father or whoever it is, on behalf of that person. Now, there's one or two things that we need to know. Firstly, the document is in Hebrew. It's in Hebrew, but everything can be done in English. That's to say, the explanations are done in English, the discussions are done in English. It would be preferable for the lawyer to draw up the instructions in English so that you understand them, and then he will put it into Hebrew, because it's the Hebrew form which counts. Now, every person's power of attorney is a separate item. The husband's power of attorney is not the same as the wife's. There's no such thing as a joint power of attorney. It's what I want is what I want. What my wife wants is what she wants, and they are different. As far as the procedure is concerned, then we've pretty well covered that. It's fairly simple. One thing is, you may wish to know what is the cost of these things. Oh, before we go on to the cost, let's just see what the limits of the power of attorney are. There are limits. The power of attorney will not enable your attorney to do very large business deals without court approval. I can't tell you what a large business deal is. You probably, for the sale of your house, you will need the court approval. But of course, if you've written in your power of attorney that you would like him to sell the house, or you give him permission to sell the house, there's no problem with getting court approval. People that you cannot appoint as your powers of attorney are people in your employ. That is to say, you can't appoint the lawyer who makes that power of attorney as your power of attorney. You can't appoint your landlord. You can't appoint your tenant. You can't appoint your employee. You can't appoint your social worker. This is to prevent any conflict of interest situation where the person very close to you in that sense, not part of the family, is very close to you, has some sort of control on what you're doing. Apart from that, I think everything can be dealt with exactly in the way that you want. Just a word about the validity of the document. The validity of the document in Israel is total. The law requires every authority to recognize that document. This document is not valid outside Israel at all. It would not apply to your assets or affairs abroad. However, if this document, properly translated and notarized, etc., is shown to somebody abroad as to be what are your own specific instructions, what you would like to do, it's fairly persuasive, but it's not binding, and it has no legal force outside the country. Okay, I think that covers about everything, except the thing which everybody asks: how much does it cost? How long does it take? Well, before I go there is a recognised fee, recognised by the Bar Council and by other practitioners. It's 5,000 shekel plus VAT for a single power of attorney, and if you do husband and wife together, it's 7,500 plus VAT for the two powers of attorney. The procedure can take as little as a day, as much as several months, depends on how long it takes you to make up your own mind, and the availability of a lawyer, obviously. But essentially, there should be two main meetings of the lawyer with the client, two main meetings. Then the period that it takes for everybody to come and sign, that can take a long time sometimes. Sometimes it can be done on the spot. And at that point, it goes into the ministry, and the ministry these days is very, very quick. And within 3 or 4 days, maximum a week, we get the answer. And I can say that all my applications are approved. I think I only had one which wasn't approved. That was a few years ago after it first came out, when everybody was new at the game. And that was not approved. Otherwise, I think I've done around about 70, 75 already, and they've all been approved. So it can all be dealt with in a very short time, provided everybody cooperates. The cost you know, the procedure you know, the details you know. It's now up to you. You'll realize why it is probably more important to have an enduring power of attorney than it is to have a will. And just one reason why. A will, if you don't make a will, most often what will happen to your assets is going to be the same thing as what would have happened had you made a will. Most times, not always. But with the power of attorney, it's not. That's why it's just as important, if not more important. So here we are. That's my talk. I hope you enjoyed it. Nice speaking to you. Thank you very much.